So, welcome back, everybody in the room and everybody online, wherever in the world you are. In this next session, I'm delighted to tell you, as you'll have seen on the agenda, we have three regulators, two from Ireland, Anna Morgan, Deputy Commissioner of the Irish Data Protection Commission, and a member of the European Data Protection Board, incredibly important player in this space, and Jenny Dolan, who works with Anna and is an Assistant Commissioner in the Irish Data Protection Commission. And we've also got from Slovakia, Lubos Kuklis, who is also chair of the European Platform of Regulatory Authorities. ERGA, I think, is their acronym. Now, what we thought would be better with this session was rather than ask them to these regulators to make a presentation like the earlier speakers did do, we thought it would be better to handle it as a Q&A. And I've got some questions ready, which I thought would be a good way of getting the conversation going. So I'm going to ask it to all three of you, and I'm not quite sure how we're going to handle it in Dublin, which of the two will speak, but I'm sure you'll have worked something out. And then Lubos as well, if you want to jump in to make any remarks that you wanted to make. So here's my first question. So from your perspective as a regulator for data protection, why are age assurance and parental consent such important concepts for the purposes of GDPR compliance? So Anna, are you going to go first?
I'll hop in here. I'll take the first question. So good afternoon and very many thanks for the invitation to participate in this really important conference. So I suppose the starting point here is that the Irish Data Protection Commission as a regulator is responsible for enforcing and monitoring compliance by organisations with various data protection rules. And most especially, of course, we have those rules that are set out under the GDPR. So when we approach these issues around age assurance and parental consent, the DPC as a data protection regulator is always going to have to do that primarily through the prism of the GDPR. So I think from a data protection perspective, it's important to distinguish between those more broadly understood connotations of these concepts in the digital world, and then separately what we mean when we talk about them in the very specific context of the GDPR world and the data controller's obligations under the GDPR. So I suppose I might just turn to consider each of those concepts individually. So firstly, on the issue of parental consent, of course, the common understanding of this idea in the digital environment might be that it entails an organization deciding as part of its own user rules that consent must be given by a parent of a child if that child wants to go online or sign up or access or use that service. And in those circumstances, the parental consent that's sought is essentially going to be implemented as part of a safety and supervision measure. But then on the other hand, when we talk about parental consent in the very specific context of the GDPR and the lens of Article 8 in particular, which as everyone knows is the article that sets out the rules around the age of digital consent, we're into quite different territory. And of course, Article 8 of the GDPR states that if an information society service, so we're talking about websites and apps, if those services are being offered directly to a child and that service provider is relying on consent as the legal basis for processing data under the GDPR, and the child is under the age of digital consent, then the consent must actually be obtained from the holder of parental responsibility. And of course, as we all know, the age of digital consent varies between 13 and 16 across various member states. And in Ireland, in fact, it's set at 16. So I suppose it's important at this point just to emphasize that the age of digital consent itself is not an online safety measure, and it's not a requirement that children under that age threshold are prevented from accessing websites or apps or digital services. Instead, it's very much a data protection rule related to the requirements under Article 5 and Article 6 of the GDPR that any organisation that processes personal data must have a legal basis for doing so. So I suppose that then brings us on to the question of how an organisation that collects that consent can be certain that consent has been given by the person who is actually the parent or guardian. In other words, to use the terminology of the GDPR, the holder of parental responsibility. Well, in that case, the GDPR tells us that the organisation collecting the consent must make reasonable efforts to verify this, taking into consideration available technology. So obviously then that means that effective measures for verifying parental consent are of paramount importance for compliance with Article 8 of the GDPR for those organisations that will be relying on consent as a legal basis for processing data. So then moving on to the separate concept of age assurance, I suppose the first thing to point out here is that there's no mention of age assurance anywhere in the GDPR, whether in Article 8 or otherwise. And importantly, Article 8 does not state that organisations should carry out age assurance in order to comply with its requirements. But as I've mentioned, there is that issue of having to make reasonable efforts to verify where a child is below the age of digital consent that the consent has been given by the parent or guardian. So in order to get to that point where an organisation can actually verify that a parent or guardian has given consent to the processing of their child's personal data by the service provider, it's in most cases going to be very likely that the organisation is going to have to ascertain firstly that the child is under the age of digital consent in the relevant member state. So I suppose then why the GDPR doesn't contain an explicit requirement to verify the age of users, whether or not they are under the age of digital consent. This is in reality the practical implication of Article 8 of the GDPR in most cases, and that has been recognised by the European Data Protection Board in its own guidance on consent. Now, all of that said, Article 8 of the GDPR and those very specific data protection rules are only one of the situations where age assurance methods might be employed or might need to be employed for the purposes of complying with data protection law. So as we all know, the GDPR requires organisations to very much implement higher standards of protection when processing children's personal data. And we see this borne out in provisions such as Article 12, the transparency requirements that says controllers should take appropriate measures when providing information to children on the processing of their data. We see it in the indicators in recital 71 that children should not be subject to profiling or automated decision making. And overall, we see it in that very important recital number 38, which kind of sets out the overarching principle of the GDPR concerning children, which is that they merit specific protection because they may be less aware of the risks and the rules and the safeguards and indeed their own data protection rights. So I suppose as a result of this obligation to protect children, organisations may very well need to undertake age assurance for the purposes of establishing whether a user is under the age of 18, whether they are a child and they deserve those higher standards of protection, so that the organisation can then in turn ensure that they apply the very highest standards of data protection to child users. So this is essentially where age assurance and effective mechanisms for age assurance are really playing a vital role when it comes to compliance with many aspects of data protection law. And I suppose just before I finish up, I'm sure I've kind of run over time a little bit, but I do think it's important to highlight that if organisations choose not to go down the road of age assurance, then the DPC's perspective at least is that those organisations must apply a floor of protection across all of their services, and that essentially means that they must ensure that all users, irrespective of whether they're over or under the age of 18, must benefit from a very high standardised level of data protection that is essentially sufficient to protect the rights of all child users. So I suppose I'll finish by saying there's no specific requirement in the GDPR for organisations to conduct age assurance, but it does remain a very important vehicle by which data controllers can ensure that they apply those very high standards of protection that are required of them under the GDPR when it comes to dealing with children's data.
Thanks very much, Anna. And that was a timely reminder that there are two things going on here. One is in relation to the obligation to obtain parental consent, and different countries have adopted different minimum criteria. But then there is the wider obligation in relation to all children that being a person under the age of 18, and the two things are not the same. They are quite different. So